Hello, if you're watching this video, it's because you received a USPTO office action right there. And what that means is you received a letter that has either issues or rejections that need to be responded to in order for your application to move on to publication. In this chart, it says 6 months, but there's going to be a new law soon that it's going to actually be shortened, and you'd have to pay for extra months. So just be aware of that by the time you watch this might not be accurate because they are moving to a system that's more similar to patents where you only get a couple of free months to respond, and then after that you will have to pay to get the full 6 months of time to respond, or even if they go to, I believe they're going to do a 2-month response window, so even to get 3 months you have to pay for that 3rd month or for the 4th month. But right now, time of recording this, that's not the case. So what is an office action? It looks something like this. Most cases it's all done through email. You would receive it. Things that are important to note in it is the date that it was issued, because that's where all your deadlines stem from, and then whether or not, as I said, this at time of recording this, it's a 6-month window, but in the future it might be longer, and if you do not respond to this, your application will go abandoned. So this is one, it's not one that I filed, I just looked for one that had a good number of rejections to kind of show you what things are. So here we're seeing a likelihood of confusion and also prior filed applications. So if someone files before you, but they do not have a registration yet, their application is pending, the examiners generally will just cite it as a prior filed application and pretty much punt the application down the road. If there's no other issues, they would have just put it in what's called suspension. And what that means is that they're just going to check every 6 months to see what happened to those trademarks that they cited against you as prior pending. If any of them result in registrations, then they will most likely issue a 2D likelihood of confusion rejection. If they go abandoned because the person doesn't respond or they can't overcome it, then your application might move forward. So here, as I said, there's prior filed applications, there's a 2D likelihood of confusion. There's also a merely descriptive, which is most likely because there's BK in the mark, and BK stands for Brooklyn for people that don't know. And as you can see, the likelihood of confusion one is against BLK root beer, and I'm guessing all of those are for the same type of goods. So I'm not going to go through the whole rejection and give you an analysis. I'm just trying to give you an idea of what an office action is here. Then there's going to be a request for information. Examiners are allowed to ask you questions that you have to respond to. About the goods, about competitors, things like that, to get an idea of how descriptive this trademark is, or just to give an idea of what the type of products are to make sure that it's proper, that it's classified properly. And then sometimes they'll even ask you to disclaim words. Like here, they're asking for root beer. Root beer is descriptive of the product, and you can't stop a competitor from using the word root beer, so they ask you to disclaim the mark there. And what that means is that, a competitor for the same exact product can use the word root beer, but they cannot use your full mark that you filed for, assuming it goes through with registration. So, and then down at the bottom here is where the examining attorney's info usually is. So sometimes, depending on the issue, you can reach out to the examining attorney by calling them or by emailing them. Just know that if you do email them, whatever you say there, will be put on the record. Whereas a phone call sometimes might not necessarily be on the record, depending upon how you talk and what you ask for. So that's at that phase. And then assuming you're able to overcome it, then you would go over to the publication, which is right here. If you're unable to overcome it, if you're unable to persuade the examiner that your application should move forward for publication, then usually what will happen is they will issue what's called a final office action, which is essentially, and starts another, at the time of recording this again, starts another 6-month period of being able to put in a response, as well as that's when you can appeal. There's some other timelines in there that you need to be aware of in order to maintain the application. Of course, if you do nothing, if you do not respond, then the application will go abandoned, and nothing happens with it then. So if you're our client watching this, we can have a call to discuss how to respond to your office action. If you're not a client watching this, then feel free to reach out and see how we can help. Thanks.